Welcome to Rebel Chaser. My name is Gail, and I have a clip for you from Judge Stevens in Texas. All hell broke loose during this hearing. This is a bond hearing for a man that's been in jail for 2.5 years. And it turns out that maybe he shouldn't be in jail at all. I'll let you guys watch.
Okay, back to David Allen Tovar.
So that's the bond hearing that's set for today, Judge.
It's a bond hearing. Is that what we're doing?
Yes, sir.
Okay. Where is he?
He is in custody.
Are you representing him?
Yes.
Okay.
Because we have it also as pro se / you, because I think since the last writ hearing we had, he'd wanted to represent himself.
Are you familiar with that, or
I am.
or have you talked to him about that lately?
No, sir.
Well, you certainly talked to him before we came in today.
I mean, we've exchanged communication several times, but nothing about representing himself.
Because he's filing things pro se. Surprise?
Yes. I mean, I haven't, obviously the court emails
And
us
buying
things
through
that
pro se, he's calling himself pro se in this cost number. Come forward, sir.
What was that filing, Joe?
22 May 8th. 22-4114. That another 4? Yeah. 41144 is called the state of Texas versus David Tovar. Are you Mr. Tovar?
Sir.
Present. Is Mr. Wilkerson your attorney or not?
Sir.
He is, because you've filed something pro se, which you can't do. You got to go through him. You can't do what is called hybrid representation. You either represent yourself, which you can do if that's what you really want, or you're going to work with your attorney, but you can't be filing things without him signing them if he's your lawyer. And if you do pro se, then it's really not considered because you've got a lawyer already. Something is called writ to compel the court. This was filed on May 8th of 2024. You remember doing that?
So
what's that for? Because I'm trying to read this, and that's why it's always good to have a lawyer taking care of it, because they know how to write things in the legal way. But I'm just confused. What are you asking for?
I was asking for a letter of incarceration, my incarceration.
What does that mean?
It's
I've been doing this a long time. Has anybody ever heard of a letter of incarceration? No, none of us have. We don't. What do you mean? You're probably using the term wrong, but if you'll describe what it is you want, I can probably figure it out. Because I've never heard of such a thing, and I've done this for 40 years.
I'm sorry. A letter proving that I've been incarcerated in JCCF.
For what purpose? No, for what purpose do you need that?
To file with for an appendix for writ habeas corpus that was denied recently.
Oh, okay. Well, the documents of this court in this court case probably has all the evidence, all the information that you need. I'm looking at things, applications for writs filed by your attorney going back to 2022. So, yeah, this was filed by Mr. Wilkerson here on November of 2022.
If I'm understanding what he's requesting correctly, Judge, I think it's something representing that he's been in continuous confinement. Is that, okay,
Well, that is going to be in the records.
I think we have to get that from the jail or the sheriff's office, Judge. We don't hold on to it.
Have you been in the county jail, Jefferson County? Okay, they're the ones that. When we ever get information on a defendant to know how much time has been served, that's what we do, is we contact the jail and they provide us that data. We don't have direct access to that information because it's never been necessary. We're not the ones who are supposed to document it. They are, because they're the ones who have your body. Habeas corpus, have your body. And but that's who and he knows how to do that. In fact, we could probably figure out.
We can tell him how much time credit he has, Judge.
We can tell you how much time credit, but
I can't give an official document. I would think he would put that in the
yeah,
jail.
we can just give you time credit. Information. Is that what you want, or you want something official, right?
Yes, Your Honor, because,
Yeah.
The Ninth Court of Appeals recommended that I have a proof to prove that I was been in there.
Yeah, I know, but what are you doing? What are you doing with the night? What are you doing communicating with them? You gotta go through your lawyer. If you have a lawyer, that's hybrid and they will scold you.
Yes,
Okay.
sir.
Show that he's been in jail for 646 days.
That's what they're showing. What information that we can get. What do you want to do today? You've got,
yes, we've got a writ hearing scheduled for bond reduction, Judge. Court previously increased the bond and added some conditions. The writ was based on several things. First, records having not been turned over, that has been remedied since that writ was filed as recently as last month, I believe. Those were turned over. Second reason, due to the state's request to try the newer case involving another perpetrator against the same complaining witness prior to this case. The state's represented that they're ready to try the case as it comes up on the docket. So and neither one of us have any control over that. So that kind of deals with that. The only other
I
issue.
don't understand.
We had told Marcus that we would prefer to try,
Mr. Wilkerson.
Mr. Wilkerson, I'm
Yeah.
sorry. To try the other defendant first, but I am
Not Mr. Tovar.
not Mr. Tovar, Mr. Grant. We would, however, try them as they come up on the docket. The state is ready. The state is willing and ready to try it whenever it comes up on a trial
When are
docket.
they coming up? Is this one set for trial? Is Mr. Tovar set for trial?
It has been, Judge.
When is it rolling around again?
Judge, I don't think we have a current trial setting on it. I can get it with you this summer, but we don't currently have a trial setting. I think it was taken off that trial docket. for
Why?
this written hearings.
It was to resolve those discovery issues, Judge. I recall that was when Mr. Hallpower had the
Well, I think
file and there was issues.
I think a trial can also resolve the writ hearing,
But
the
Your
writ
Honor,
issues too.
I do recall the court placing it back onto an ancillary docket to resolve the discovery issue.
There were some medical
We've
records
had
that
that
were,
setting since then.
Okay, we've taken care of that, you're
Yes.
saying, Mr. Ham? Oh,
Yes, sir.
all right.
That's my understanding.
Are y'all ready for trial?
yes, Your Honor.
Okay,
we
we'll
are-
set this one for, number one, let's get it set on a trial docket. As soon as possible, and this nature of this case is gonna make it a prioritized case.
And then the final aspect of the hearing, Judge, was to present testimony from 3 witnesses regarding the origination of the accusation by the complaining witness.
Okay,
So
That's a little
the court had
odd.
previously represented that it would entertain testimony regarding this allegation having been made and the circumstances surrounding it having been made. So essentially, what our intent is to present evidence regarding the outcry, but obviously the court's not going to try the case before it tries the case. And so kind of condense down the information to provide to the court regarding the outcry and consideration of this bond.
Okay. Number one, you don't get to have writ hearings for the sake of discovery if you're not entitled to discovery on matters. If that's what you're trying to figure out, especially when we're dealing with children who are complainants or victims in a case, what is it who is it you're going to be calling?
I'll be calling the defendant's wife, her mother, and the cousin of the complaining witness.
And what is summarize what you proffer they will say?
Your Honor, they will testify regarding the circumstances of the home, how many people live there, and I would say unavailability of a time when the house was essentially dead quiet, that there wasn't somebody up and moving around, and with regard to all of the people who were living there. There would also be testimony regarding the presence of a small birth defect, namely an external hymen, that disappeared only upon the representation within her journal of her first sexual act. And so we would be presenting that as proof that he could not have, at least prior to that, engaged in the acts as alleged. Finally, we would be presenting testimony regarding the complaining witness making representations to her cousins that this didn't happen, that she wanted to punish him for his prior offense. That is the offense that had occurred a number of years ago before he was associated with this family in any way.
How do you know that information is going to be made? How do you know that that's what that witness is going to say?
I mean, I've got an affidavit. I've spoken to the witness.
Do you know?
I don't
does
know
the
any of this. And
State of Texas know anything about victims in your case, that they are approaching victims and trying to get information from them?
no, as far as I'm aware, this happened prior to the indictment, as Mr. Wilkerson has told us. I, however, don't understand what any of this has to do with a bond hearing or why it's necessary for a writ hearing. This sounds like things that would be brought by defense at trial when we try the case, when it's brought up, but I don't understand why this is necessary for a bond hearing.
Go ahead.
I mean, the court has previously represented its willingness to consider the information with regard to the specific element of considering the facts and circumstances surrounding the outcry, Judge. I'm not sure what the court means about approaching victims to receive information. I have never personally had any contact with the complaining witness, nor has my client in any manner, shape, form, or fashion.
Well, how do you know that's what they're going to say? How do you know what they're going to testify to?
What?
Who are you presenting today? The people who are identified here?
No, Your Honor, I would be presenting.
Well, you hadn't explained it well enough for me.
Okay, I would be presenting it with regard to that particular issue.
Any issue you want to present today, who are you going to call and give me a summary of what they're supposed to say?
All right, I'll be calling Mr. Tovar's mother-in-law, who will testify regarding the number of people that were living in the house. And
Okay, next.
All right, I will be calling, Ms. Tovar, who will be testifying regarding, the
Who's Miss
complaining,
Tovar?
Carlina Tovar, the defendant's spouse,
Okay,
and mother of the complaining witness, who will testify regarding the external. And then finally, I will be calling Elizabeth Torres, who will testify, and this is prior to the
who is
indictment.
this? Who is
This
that?
is the cousin of the complaining witness, Your Honor, who will testify that the complaining witness had previously advised that this never happened, that she was trying to punish Mr. Tovar for a prior offense.
All right, you know, if you had this information, why haven't you run like the wind over to the DA's office, since that's all exculpatory?
Judge, I have provided this information to the DA's
That
office.
exact
It's been through-
information?
Yes, Your Honor, and it's been
To this
through-
lady?
Not to her specifically, Judge. It's been through several iterations of prosecutors.
Who were the prosecutors you gave them to get information?
Originally, I provided the information to Ms. Duchamp, and after
Who else?
Mr. Hoffpower was appointed on the case, we discussed the matters, but not in depth. I have not discussed these specific facts with the current prosecutor
Okay.
assigned to the case.
How long have you been on this one?
Since I started in this court, Your Honor, about 2 months ago.
Okay,
So,
this,
This is news to me.
okay,
and prior to Mr. Hoffpower, there was a brief period where Sonny had the case. So, like I said, it's been through multiple iterations of prosecutors. However, all of the information should be available and in the state's file. I'm certainly willing to provide
okay,
it.
who do you want to call first?
I'd like to call Carlina Tovar.
Okay, let's get this done. Y'all sit and we'll get this hearing done. Raise your right hand. Do you solemnly swear or affirm testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Turn the microphone toward your voice, please. Thank you. There you go. You may need to move. There you go. Go ahead.
Good afternoon, Ms. Tovar. Could you state your name for the record?
Carlina Maria Tovar,
And what's your relationship to the defendant?
he's my husband,
What is your relationship to the complaining witness?
my daughter,
And for the record, what is her name? Okay, last name?
Marston.
Marston, got you. And so,
Where does the complainant live?
Right now, she lives with her boyfriend and his mom.
Where's that?
I,
What, you don't even know where she lives?
she moved out of her dad's house about 2 months ago. I was,
Okay. How old is she?
she's 17. She just turned 17.
Go ahead.
all right. You're familiar with the allegations that Jaden has levied against Mr. Tovar, correct? And just for the court's awareness, when you were a child, you were also victimized, is that correct? And while it's tangential to this matter, every time that individual's come up for parole, you have gone to oppose that parole, is that correct?
Yes.
Okay, so you're familiar with what it is to be victimized as a child. Can you tell the court what specifically an external is?
I didn't, my first baby, I didn't know after she was born, she was in the hospital for a couple months. Upon bringing her home, bunch of medicine, we wanted to go to the doctor, to check the babies out and make sure. And then at first, it didn't stick out that much, but as months went on, it started sticking out a little bit more, and I didn't know how to clean her. Like if she poo-pooed or something in her diaper, I didn't understand how to get it out.
And so you had to request information from.
Yeah, I had to take her to Dr. Dundas, and we went there, and it was Dr. Dundas and Dr. Alswad.
Okay, and they advised you how to properly apply medication.
Yes.
Did treatment involve applying medication to the area that was outward turned on a daily basis?
Yeah,
And so is it fair to say, well, let me ask you this, were you the person who treated your daughter at
me
home?
or my mom.
Okay, and so are you aware of the time that that inverted tissue disappeared or was no longer present with Jake?
Yeah.
And can you give the approximate month and year of that to court?
That was 12. So I want to say it was in maybe early summer, like was it around the time she lost her baby, it was around the time that like she just kind of covered herself up, I guess you would say.
So there came a day when you no longer had to treat the condition. is that
Yes.
correct? And your daughter also kept journals, is that correct?
Yeah,
And there were, I believe, 12 of them at one point. Is that-
yeah.
Okay.
I think I was able to say like 9.
Okay, so at one point subsequent to these allegations, she attempted to destroy those journals. Is
Yeah.
that correct? And those journals, in part, in small part, contain information related to her history. Is that correct?
Yeah.
Is the representation contained within those journals, whether true or not, at or around the same time that the inverted tissue no longer required treatment?
Yeah.
Okay. And was that the what you understood then to be around the time she lost her virginity?
Yes.
And was that subsequent to the time that a portion of these allegations have been levied against your husband, Mr. Coble? Was that after, what I'm asking you to explain to the court is, did that disappearance and that representation occur after a portion of the time that your daughter indicated Mr. Tovar had been in these allegations?
Like, I'm not understanding what you're saying.
Okay, your daughter made allegations.
Like she lost her and then like
Your
and
daughter-
then she made the complaints or.
Your daughter made allegations that spanned a certain period of time.
Oh,
Is that
yeah,
correct?
okay, yeah.
And do you recall when she alleged the behavior to have first started taking place?
Well, whenever me and her first discussed it, she said that she was like 8. But I don't know what you know, everybody else had one else.
Okay, so when she made an outcry to you, she represented that it had begun when she was 8 years
Yeah,
old.
she told me that he when she was 8.
And did you know that to be false based on the fact that that inverted tissue was still present?
Not only the inverted tissue, but she had surgery within those times as well. So not only, I wouldn't have been the only one to see it because her doctors knew it was there, so.
Right. Okay, and so in this particular instance, it's your belief, or do you believe that your daughter had other motivations for making these allegations?
Yeah.
Did that include a motivation of getting back at you for your, how would you have described your presence or your interactions between your daughter and the outside world?
At school, Jaden was a different Jaden than I had at home. And Jaden I had at home was feisty, you know, like she was. The counselor told me she was a regular kid, so like, what do I, when that's my first child to attend to, so what am I supposed to do?
So,
But like outside of that, you know, Jaden at home was doing different.
how would you describe your parenting style as it pertained to your children?
I don't know how to call them.
What do you mean by that?
That means I like to be with my kids.
I like to go with my kids, me and Jaden, it was me and Jaden for the longest time, before Mr. Tovar, and I had 2 other children, came into the home, it was just me and Jaden. Yes, I was married to her dad, he was gone. So, we did everything. And it didn't stop just because I remarried and had other kids, like, you know, that's not to be ugly, but David is not her dad. So there's certain things in my household, or the way I grew up, that you don't do. He's not gonna take her to go to this game with ring with her friend. I am. I'm gonna say, I'm gonna take her to the movies, I'm gonna do this. So we still had our daughter dates and everyday things, but like,
So is that to say that you were
Um,
heavily involved
yeah.
with your daughter's
school,
life?
home, friend.
When did she first make the allegation to you that she had been abused by David?
Actually, I had she was on, I call her a sad chat. Like, if she wanted to be sad, she would go on the internet and would create like a Google things. And I'd turn off the internet because we weren't allowed to have internet, but she said that in a group chat. She had snuck her tablet. I realized her tablet was in a different spot, so I went snooping to see what she was doing. And then, of course, I found a whole bunch of stuff that she had deleted, but that was like the second thing that I looked at. She had said that she'd been getting since she was 8. So I went and woke her up and asked her.
And so it's your representation then that you discovered her having made these allegations to strangers in chat groups
Yes.
Via her communications. Is
Yeah.
that electronic communications,
Yeah.
correct? Okay, and then you approached her about the allegation?
Yeah, I went and woke her up like 2 seconds later.
Are you aware of how long, or let me ask you this first, was Jade in counseling during
Yeah.
the course of the time that she made these allegations?
Jaden's been in counseling since about the time me and her dad divorced, or like when the divorce was finalized, so probably like 2014, like the beginning, maybe like 13, 14, 15, but it's been since before Mr. Tovar came home.
Okay. And are you aware of whether or not she ever informed her counselor regarding the allegations about Mr. Tovar?
I actually.
Objection, Your Honor, this would be speculation. She is not the counselor in question.
I'm asking if she's aware, Judge.
I told the counselors,
Oh,
and then it took 3 months for Jaden to tell the counselors.
So,
And that's documented.
so you advised the counselor of the natures of the allegations?
Yeah. I called her the same day.
Long before she ever made the allegations to the counselor, is that correct? And, had Jaden been, exhibiting since, the additional children and Mr. Tovar came into your life, had she been, exhibiting, behavior that was jealous in nature?
Yeah.
And, as her mother and, as a survivor of, being when you were a child, based on all of the circumstances that you know to be true, is it your belief that she has been dishonest about these allegations? Does it, how does,
When did you figure that out?
That,
When did you figure out?
but she was
That
doing
you-
something
Yeah, when?
within the first week, because,
Wait, first week, what, give me a date.
so,
Years ago?
like 2 years ago. Well, okay, so it would have been, since he got arrested August 31st, and she told the counselors in October, it was 3 months before that. So we had 3 months of communication back and forth with doctors, back and forth with the counselor, back and forth with everything.
No, who would, when this happened, of course,
Oh,
not to wait 2 years to
Oh.
drop this on everybody. Something that is going to incarcerate this man. So why didn't you run like the wind and give news conferences, tell the prosecution, say, the
Oh.
grand jury, let me speak before you butt in. The grand jury indicted, you know, there was an investigation going on. Who did you tell during this investigation? Hey, y'all, this child doesn't have any credibility. Who is it you told that misled the grand jury? I want to know how this grand jury got misled, and the DA's office, how they're misled.
Robert Campbell,
Who is that?
the detective that was on the case.
Okay,
I,
how did he mislead them?
I don't know.
Well, you said Robert Campbell.
Yeah, he was the detective on the case that investigated everything.
So-
I worked with him, like, I've never worked in against anybody. And neither has Mr. Tovar.
Wait. I see a document here dated 2021 that appears to be, the affiant is, Campbell, and it's Detective Robert Campbell, who files a probable cause affidavit that is saying something completely different from what you're talking about, but alleges that on October 6th of 2021, investigation began on continuous of a child in this case, and then based upon the investigation, asked that a warrant be authorized to arrest the defendant, and this is dated December of 2021.
Mhm.
Okay, it's June of 2023. This is only coming out 2.5 years later after what you're saying, this cover up and total injustice has occurred. I'm finding out about this and the DA's office didn't know. And who has,
The information,
this is incredible. This doesn't happen every day. People coming forward who were close to investigation coming forward and saying there were lies 2.5 years ago. I'm just hearing about that. That hasn't been made to the DA's office. Y'all haven't been screaming to the press. Truly?
I wanted to go, but every time I tried to do something, I didn't want to hurt the case or anything. But this is, I've been open.
Well, wait,
honest.
what's the difference now? What has prompted you to come forward now? What's different?
I
Except
think-
he's just been in jail for a long time.
Yeah, but I mean, I've been coming forward, like even whenever.
Who have you talked to?
Well, before I hired him, I was Detective Campbell. It was working with Detective Campbell and getting any information that he needed, getting the journals, getting the documents, getting the medical records, getting the DCF records, getting CPR.
Wait,
records,
who
CPS.
else did you, so you completely told this to Mr. Campbell, right? Who else?
Just Detective Campbell and
All right.
counselors. I've let Marcus know. I've never
Give him
let-
up, get him up here.
Detective Campbell, too.
I'm not talking to you, I'm talking to the state. I'd like to
But
get to the bottom of this because she's alleging a cover up.
Yes, sir.
Which this court doesn't take lightly.
no, I'm just not what I was implying. I was just.
Oh, yeah, you are.
I'll just remind Your Honor, we did not know that they were going in this direction. Have we had any heads up?
Well, I've never known you
So-
to not come forth with information that would affect the sanctity of a grand jury investigation. Yeah, if you have that, you always come forward. That's why we're gonna get to the bottom of this real quick. I wanna know who's lying and who's not lying, who's covering up, and people will be held responsible.
Yes,
That's
sir.
what I do.
Yes,
So,
sir.
Judge, just for the court's information, it's my understanding that all of the materials, as well as Ms. Tovar's opinion, had been all represented to Detective Campbell prior.
We'll
to-
find out. Well, let's see. And maybe he just felt she wasn't worth believing too. But
That-
based upon his investigation.
That's possible, Judge.
But I've never heard of accusations like this that have not, when there's sincerity to it, people aren't screaming and reaching out right and left. This is 2.5 years has gone by. Is that right? 2.5 years? 2.5 years? And we're just sitting, people, you're saying, oh, I've been telling people about it, and people have covered up and sat on these allegations of a cover up on a child, on continuous of a child. There's nothing more important. We're going to get to the bottom of this fast. This is terrible. One way or the other, it's terrible. The system is not broken. It works. And somebody is tinkering with the system right now. We'll figure out who it is. Are y'all getting Mr. Campbell?
Your Honor, we're gonna revoke the rule. These folks are making comments and I want them removed so that.
I warned them already, Judge.
Go outside.
It's one on the end right there.
You can go outside. You are ordered to remain outside. If you're going to be disruptive according to the bailiffs, that's inappropriate. That's not the way we conduct. Go outside. Thank you. Immediately.
If they have additional witnesses, we'd like for them to be.
What'd you just say, ma'am?
And she's moving as fast as she can, Judge.
Thank you.
We would invoke the rule so that any other witnesses are removed as well, Judge.
Y'all are ordered to remain outside unless and until you're called forth, all of you. Remain outside. Thank you.
Prior to.
Ma'am, this is very serious. We're gonna get to the bottom of this as fast as we can because something is wrong. According to what I'm hearing, this is a terrible misjustice one way or the other. Okay, go ahead.
So, prior to this investigation being turned over to the DA's office, had you discussed your belief that, that Jaden was not being honest with Detective King?
Yes.
And you had, and they're part of discovery, but you additionally provided the 9 journals that you were able to retrieve from the trash, correct?
We gave them what you want.
And did you explain at that time that, that she had attempted to destroy the journals or dispose of them? And did you explain the nature of the medical condition that she had with regard to the inverted and in addition to all of that, did you explain the I guess the dynamics of the family relationship to Detective Kim?
Yes.
And so, and ultimately, and was Detective Kim, you said, you just talked about getting medical records, and providing them to the detective.
I got him floor plan, pictures, anything that he wants videos.
Did, those medical records include, the counseling records,
Yes.
with regard to, you contacting the counselor and then, Jaden talking to the counselor about it some 3 months later?
Yeah, I had a text message thing with her main counselor. And it's in the file.
Was, do you recall making the detective aware of Jaden's representation to her cousins?
I don't remember, but I think maybe, I don't know.
So you're not certain that you told him about what she told Elizabeth and Ryan, Rhiannon?
I don't know if that was, no, I think I did. I don't know if that was before or after because Jaden outsourced them. They weren't like,
I don't know what that means.
they're not close cousins, like, you know, you have cousins at your house all the time and stuff like that, because they're a little bit older than. So a lot older than her. So they just talk like on the internet, Snapchat. Maybe.
And
So more than likely, yeah.
you brought up very briefly that Jaden had, or actually, I don't think you did, had Jaden, accused a childhood friend of having, a
Objection, Your Honor, that's hearsay.
judge, we don't believe it's true. In fact, we're not offering it to say that it actually happened.
To say that it's not true is to offer it for the truth of the matter asserted.
We're trying to make the court aware of the circumstances surrounding that, including the relative ages, Judge.
Well, then they should call the witness that they need to get that in. They can't get it in through this witness. It's hearsay.
Well, it is hearsay.
The information that you were just inquired about, that would be contained within Jaden's own journals as well. Is that correct? Pass the witness.
Do you remember attending a polygraph examination with your husband? Do you remember getting the results back from that polygraph examination?
No.
Do you remember the officer telling you that he failed it?
Objection, hearsay, Your Honor.
Okay.
Yeah, I
I'm gonna
don't-
overruled the objection, but what do you know about?
So that day that we went in there, we were sitting in the office, like he had brought me back in there and he was like, well, he failed it. And I said, okay. I said, bring him in here. I would like for him to tell me that because that's gonna be a different story. And then he told me I could leave.
Do you remember making excuses for your husband to that officer? Are you a medical professional?
No.
Are you aware of how prosecution can occur legally? Do you know the legal definition of prosecution?
Not the legal definition.
Do you know that it is merely going between the,
Oh, okay.
and that could have occurred with her external, couldn't it?
No. Where's the access?
Between the,
No, 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 oh, no, not that. His access to my daughter.
okay, he was never alone with her ever,
No. Well,
not
no,
one,
I do take that back. He was alone with her one time when they went to the daddy dog games.
never once, never ever, and the, between 8 and 14, was he ever alone with her, not once?
No, that's not her dad. He doesn't live like that in my house.
I have no further questions for this witness, Your Honor.
Anything else on this?
Just
Go ahead.
very briefly, what makes you comfortable in saying that he was never alone with her with regard to any potential, that could have occurred, or was alleged to occur in the home where y'all were residing?
That's the one day he gets, because that's not her dad. I don't care who you are or where you are. You can ask my ex-husband. We have the same policy. Like, me and her dad are the same on that. He didn't even move in until April. A whole month after his son was born. Actually, it was at the end of April, beginning of May. That is not her dad. He doesn't get to take her to the store. He doesn't get to take her down the road. He doesn't get to take her to work. He doesn't get to know about her medical, anything medical. That's not her dad. Her dad gets to know that. She has a dad. Her dad is alive. Her dad is well. Her dad is all this. If I had a problem, he wasn't even allowed to punish her. Because that's not his job.
So you said you didn't move in until April after his son was born. When was that?
I had the 3/14/15, I had March 14, 2015. Mr. Tovar is, he has to register, so he didn't want to register until after his birthday. But also the same fact, he lived with his mother. So after our son came home, it was, y'all probably have to look at what they have on record on when he went down there and verified everything and said he was gonna move, and then he moved in 2 days later.
Okay.
So that was something that I did try to get the information on, but
What makes you believe that he didn't have access to her while people were asleep in the house?
Because my mom's awake all the time and that isn't her baby. I have my baby, he has his baby, and I know that sounds weird, but I have two boys 15 months apart. We
Well-
also have baby monitors all around the house, and if you turn the baby monitors off on the other side, they beep. And that stayed with me, and I'm pretty sure I brought that to somebody, and I don't remember who I brought that to.
So, what were the circumstances in the house with regard to, where people were sleeping?
Where, well, my brother and my sister-in-law slept in the living room, which is right across the doorway from where Jaden's room was, because Jaden had her own room. The first bedroom is where me and Mr. Tovar and our two boys slept, and the back room is where my mom and her boyfriend stayed at. My mom doesn't sleep at night for some reason, so she is always up in the middle of the night. And then whenever my brother and my sister-in-law, who just recently moved out of my home, it's a lot of people in a tiny house.
So what were the hours that your brother and sister-in-law kept?
They would be home on a daily. Well, my sister-in-law didn't work for the longest time, so she was just there all the time. And then my brother would work. But whenever he worked at Crazy Cajuns, I think he got home maybe like 7.
7 PM or 7 AM?
7 p.m. And then he switched to, I don't know, all I know is that they wanted to be in bed, laid down by the time everybody went down. Jaden had a bedtime. She was still young. I let her, as she got older, her bedtime got shorter, so her bedtime was at 9 o'clock then. Because the boys were going to bed and then she would go to bed. Because we would put the boys to bed first and then he would stay with the boys, so I could spend time with Jaden. We'd read books, we'd do whatever.
How many rooms were there at first?
There's only 3 bedrooms.
3 bedrooms, and who all was living there?
Me, Mr. Tovar, our 2 sons, Jaden, my mom, and her boyfriend,
Okay,
and my brother and my sister-in-law.
so your
Hey.
brother and sister-in-law slept in the living room because there was nowhere else for
No,
them
there's no room for
to
them.
sleep? Okay. And you testified that Jaden had her own room,
Mhm.
right?
She had the middle bedroom.
Did she allege, that some of the that had occurred in the boys' rooms? Or are you?
Like the
aware?
front bedroom?
Yes.
Yeah. She said, well, I don't know, 'cause I don't know if I can, no, she didn't know that. So, yeah, so she said one occurrence happened in well, I guess it would be the boys' bedroom, but it's on my bedroom. And then in the living room.
And you said your mother would be up at night, so about what time would she get up, in the morning? When you say she was up all night, what time would she get out of bed?
When we would put the boys to bed, probably around 8:30, 9 o'clock, that was her coffee time, her TV time, and then just to chill down the house because the house was gonna get quiet. Outside of that, she's clean.
So, I mean, was she up at 3 o'clock in the morning, 4 o'clock in the morning, 5 o'clock in the morning? And this was consistent, it wasn't just one time?
No, that it is consistent. That'll be something you have to ask my brother and my sister-in-law about too as well.
Ask witness.
No questions for the
Fine.
state.
Your excuse.
Yes,
Next.
I'll call, Elizabeth Flores, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Have a seat. One of the things about bond hearings like this, it provides all parties discovery that they wouldn't have obviously known about.
The DA's office has affidavits from everybody who, including the people who are testifying here today, Judge.
But
As far as
hold on.
Checked our file, Judge. We don't have anything you just represented to the court.
So what are you talking about, Mr. Wilkerson? I mean, this is completely, what you just said is diametrically opposed by the prosecution.
So when I was first retained on this case, Judge,
Wait, who was the prosecutor you were working with on this in
the
the past?
initial prosecutor was Ms. Dusha.
How much, the people who are here to stop, for example, who's now
I'm the lead prosecutor on this case,
okay,
Your Honor.
how long have you been involved in this case?
About 2 months. I've gone through the entire file, Your Honor. I have not seen the affidavits that
Okay.
Mr. Marcus,
Okay.
Mr. Wilkerson has alleged that we have.
Okay,
For the
and
purpose-
it wouldn't be,
For
Yeah,
the purposes of this hearing, Judge, I'm printing out all the matters that have been provided to us. That comes out, as Your Honor has seen before, on those discovery certificates. So that way you've got something that indicates one way or another.
what is it to show?
I'm printing it out so that it'll be clear for the record, Judge. This is the audit log that indicates everything. I can tell Your Honor that anything that's been provided by the defense will appear on this.
Well, by the defense or what the state has gathered together in its own
Yes, sir.
work product,
Yes, sir.
but
I'm attaining that document now. so
Okay,
that you'll have
thank
something to look.
I'm looking at the probable cause affidavit, which is a very short and succinct probable cause affidavit that is prepared by Detective Campbell is what I have. And
Judge, Tatiana was the initial prosecutor that I was working with on this.
okay, so, but all of this was told to those other prosecutors?
Yes, and if we can approach, I'll tell the court off the record.
No, I don't, nothing's off the record. Either you can say it or not.
I'm not.
Well, I want. What I'm hearing is bothering me. I can't believe there are two different versions of this event.
Mark now states Exhibit 1, which is the EWE Discovery Audit Log, reports to be, it's 3 pages, but it's 2 full pages and 1 short. It's got the detail of all the discovery that's been provided to the defense. I know from the practicing reporter that anything provided by the defendant is automatically obtained as far as that is concerned.
That's what it's all in, Jimmy.
Well, thank you for writing on the exhibit.
I'm so sorry.
Do you have any objections?
No, I don't.
Counsel has written on some portion here.
Okay.
What is it? What's it? What is
referred to as the state's Exhibit 1?
On Your Honor, is something marked a grand jury packet.
Proceed.
Go ahead.
Ms. Torres, can you state your name for the record?
Well, there's no help to us.
And, what your,
Your voice is real soft and I didn't really catch it.
So, Elizabeth Torres.
There you go.
thank you. And, are you familiar with the defendant in this case?
Yes,
And how is he related to you, if at all?
that's my cousin's husband.
Okay. And when you say your cousin, is that,
Carolina.
oh, so then your relationship to the victim, the complaining witness in this case would be first cousins once removed, is that correct?
Second cousin.
Second cousin? Okay. And was there a time when yourself and, I believe, Rhiannon is your sister, is that correct?
Yeah.
Was there a time that yourself, your sister and Jaden Marsden, were all engaged in, kind of a group chat where y'all would go back and forth?
Yes.
And was there ever, did the allegations with regard to this case, were they ever discussed in that group chat?
Yes.
And, with regard to, the allegations, the underlying allegations in this case, was the alleged truth thereof ever discussed?
Say that again?
Was the truth?
I didn't understand that question. I
Okay.
can understand she's confused.
Were the
Restate.
truth of the allegations ever discussed within that chat?
Yes.
Okay. And, was there a representation made that, what had been alleged to have occurred was untrue?
Not understanding.
Did Jaden ever say that, that what she alleged David Tovar had done to her had not happened?
Objection, Your Honor, that's hearsay.
Or sustain the objection?
It is hearsay.
With regard, no, no objection to, Exhibit 2, and I believe Exhibit 2 contains all of the affidavits in this matter, Judge, that I had discussed. You previously signed an affidavit in this case, is that correct?
Yes.
And that was before Mr. Tovar was ever even indicted, is that correct?
Yes.
And did you make your affidavit based on what had been represented to you?
Yes.
Okay. And Mr. Tovar had a prior offense before he ever was involved in y'all's family, is that correct?
Yes.
Okay, and, was it your understanding, and did you, draft or was your affidavit on Mr. with regard to Mr. Tovar, based on, what had been represented to you and your sister?
Say that one time?
Was the affidavit that you drafted in favor of Mr. Tovar prior to this case going to the grand jury, was that based on what had been represented to you and your sister by the complaining witness, in this case by Jaden? Did you sign the affidavit because of what Jaden had told you?
Yes.
Would you have otherwise signed an affidavit on behalf of Mr. Tovar?
Yes.
Well, listen to the question. If Jaden had not said to you and your sister what she did, would you have signed an affidavit for Mr. Tovar's benefits?
No.
And to your understanding, was Mr. Tovar's prior offense the basis for the allegations here?
You understand that? Me neither. I don't understand.
The offense that Mr. Tovar had previously been convicted of, is it your understanding that these present allegations are made because of that original offense? Still don't understand.
Was part of the, are you saying this was what he was, these allegations are what he was convicted of in another case?
No,
There's another, he's a registered sex offender because he was convicted of.
Something before.
Yes, sir, a 20-year-old female that was the victim in that case.
When was that?
Actually, Yeah, I can have it up just 1 second. Disposition date was March 19th, 2002.
2002,
Yes, sir.
22 years ago?
Yes,
Okay.
before he had any involvement with his family.
What was he convicted of? What was the crime? Was it here in this county?
Texas Penal Code 22.011, Judge.
Continuous?
I didn't bring my book down, Judge, because again, I was not expecting us to have a factual hearing over the offense. What I thought we were having was a bond hearing, so I did not.
What is it, what's the section number?
22.011 is what the Department of Public Safety website indicates, Your Honor.
Okay, what was the sentence he received?
8 years.
That is correct.
Okay.
May I grab a water very quickly? Judge?
Yeah. Have y'all had a chance to review this
Judge,
information?
that packet I just gave you was given to the grand jury through Mr. Wilkerson before this man was ever indicted. Seems like we're basically reliving everything that you're presented there to see whether or not you're going to consider anything different. I understand that those are exhibit markers, Your Honor. I can't control how that was printed out, but what I want to submit to the court is that everything that you've heard so far, and it sounds like that they're going to attempt to let you hear, the grand jury's already heard and determined that there was probable cause.
Yeah, okay.
So it seems nothing more than an attempt for the court to change what the grand jury did, and that's not how the system works, Judge.
Your Honor, this is-
I'm looking at, hold on, this package, it says it's dated November 29th of 2022. And it's to the grand jury. It was, I guess, presented to them on or about that date. They indicted the defendant the next day, November 30th.
Yes, sir.
And it ends with an affidavit from the defendant dated November 28th of 2022, 2 days before. So this was.
That's what the state said they didn't have.
Well,
the implication that I heard, Judge,
Yeah.
is that we've been provided all this information. The reality is all that information went to the grand jury, who basically chose not to believe it and indicted the defendant. So what counsel has apparently been trying to do this
Could you-
afternoon is refund it.
yeah, Mr. Wilkerson, help me out on this one, because it's got your cover letter to the grand jury. Okay, it's dated November 29th. What did you do with this package?
Judge, that was submitted to the DA's office such it is in their discovery portal as having been provided to them such that it could be provided to the grand jury. It's my understanding that Ms. Lesniak provided it to the grand jury on the date they considered the indictment of Mr. Tovar.
Okay,
And Your Honor, I'm not trying to relitigate probable cause. However, Judge, you have said in prior matters that the nature of the allegations in conjunction with his prior conviction was the court's reasoning for increasing his bond. And so what I'm trying to show the court is that there are substantial facts and circumstances surrounding this allegation that leave questions whether or not probable cause exists, and the grand jury determined that it did, is material, Judge, but it's also material for the court to be aware of some of these other matters and determining what type of bond amount is sufficient in this case with.
but you're putting on evidence here that's essentially in this package, right?
Yes, sir.
Okay. And the grand jury, as far as you know, considered it and nonetheless voted to true bill the defendant,
As far as I'm aware, I'm applied.
stating probable cause existed for the indictment.
As far as I'm aware, they had access to and reviewed.
Okay, okay. Okay, so the grand jury decided to indict the defendant and probable cause to believe that the defendant committed this offense with this defense material that you're presenting today. And you're asking me to substitute my judgment for the grand jury with the same information the grand jury had?
I'm asking the court to consider these additional facts and circumstances when determining an appropriate bond until Mr. Tovar can be brought to trial.
Okay. But these, again, this is all information that the grand jury had, and as far as you know, considered it.
As far as I'm aware.
And they elected to indict the defendant with whatever information they had before them,
Yes, sir.
including this, what you call, might be Brady material of sorts.
Yes, you can consider that it was provided to the state, so I don't think they have necessarily an obligation to provide it back to me, but
It's Brady under the Brady decision. Is that culpatory information?
yes.
All right.
And I believe that in affixing.
So what are you presenting to me different today in this hearing that wasn't before the grand jury?
I'm not presenting anything different to you, Your Honor.
Okay.
I am asking you to consider those circumstances regarding the amount of the bond in this case.
Okay, so let's see. I don't have a history of this. So the bond in this case began how?
So the bond was initially set by a magistrate, Your Honor, I
Of,
believe at 150,000.
Okay.
And we requested a hearing for reduction. At the hearing, the court decided to increase the bond and add a number of conditions regarding to if he was ever able to post bond. As the court's aware, he's been sitting there for more than 600 days awaiting trial.
Yeah.
And given the information that the court was unaware of, that this court was unaware of in setting the bond amount, I believed it was important for the court to know of the existence of this information.
the court increased the bond to what? And we increased it because of a prior conviction that we found out about that is strangely enough not listed in the indictment. So what happened is that the magistrate who set the bond obviously probably was not aware of the prior conviction, we can assume. So he made she made the decision based upon the four corners of the indictment. And that is the question, why wasn't the prior conviction included in the indictment as an enhancement?
Probably, Judge, because this is a continuous charge. And it's pretty tough to get a bigger punishment range than 25 to life. An additional count wouldn't have changed that. That does not mean we won't present it in punishment, but it certainly is not going to change what the punishment range is going to be. Is my opinion. Now, I was not involved in making that decision, but that's what makes the most sense to me.
Yeah, it's always been in a practice that probably be prepared Boy Scout idea to put a prior conviction in there because the continuous may not proven. There might be a lesser included offense that ends up being elected as guilt by the jury, and then you don't have an enhancement ready, given notice in the indictment to go forward. I guess that can be covered later with a notice before a trial.
Yes, sir.
But anyway, so we assume the magistrate did not know of the prior conviction. It was that prior conviction that was made aware to this court that caused the enhancement, since bond conditions include not only circumstances of the alleged offense, but also criminal history, especially when it's similar in nature. So it was originally set at how much?
I believe 150.
And then I set it to,
I believe 250.
added 100,000 to it.
And
Okay.
your normal conditions that you have too, Judge.
Yeah.
It happens every time you do
Yeah.
these kind of things.
Well,
And this-
I'm not, there's nothing yet that I've heard that changes my opinion, nor does it surprise. That's what would have been reasonable for me to do in my history of the way I deal with bond issues. And also one magistrate, you know, the more information you have about the circumstances in criminal history, the better decision is made. So it is also the elephant in the room when you have a similar type of offense conviction, and if that hasn't been considered for bond, it needs to be considered. And that's what the court did, and then applied an increase based upon that. That's what makes sense, because I've been trying to figure out why it got to this.
This hearing has
And once again, this finding, this states exhibit 2, the court has heard enough on this to find, since we're not going to be able to get a lot of information out of the grand jury, it would only make reasonable sense that they considered this information like a good grand jury would before they made a decision, and decided, notwithstanding this information the defendant has provided in State's Exhibit 2, which defense considers as exculpatory, whatever information the grand jury, other information that they had, it overcame this exculpatory material and resulted in one of the most serious types of allegations and charges that can be rendered under Texas law, and that's this first-degree felony of continuous with a child. So
in this hearing.
what else do you want to provide? Because I see where we are on all of this, and if it's matters that are within the State's Exhibit 2, we don't need to rehash that, because those were considered by a fact finder already and resulted in probable cause determination, which is satisfactory to me. And then it's the additional criminal history that becomes the reasoning behind the increase in bond, which to this moment, this court deems reasonable.
And the information that would be further elicited today would be contained within those affidavits.
Okay.
Again.
All right, it'll be made a part of the record depending upon what you want to do with it in posterity here. But I've looked through it, and I can see that a lot of this information that I've heard already is within this package of documents that, again, the grand jury received and presumed to have considered before they rendered the probable cause finding of this indictment.
So, and again, Judge, it wasn't that we were attempting to overcome the probable cause finding, but just that we believed that those circumstances, that the court should be aware of those circumstances in affixing the amount of the bond in this case, especially given the defendant's inability to secure a bond.
All right.
But I note for the court that this particular
What I'm
hearing-
going to do is read through these completely, so that I'm fully informed, and I'll let you know what happens upon that, which will be done in 24 hours.
Okay, Judge, I'll pass the witness.
Anything else?
I have no question, Your Honor.
This lady can be excused. Thank you. Anything else?
No, Your Honor.
All right, anything from the state? What we'll do is, end this hearing, and I will make a decision tomorrow on after I read this and inform everybody. What's the next event? Trial.
Yes, Your Honor. I believe another
When is it
trial.
set right now?
I don't think it currently has a setting. I think Lacey was gonna put it on a trial.
Well, let's make sure that it gets set on the trial docket, because these should be fast tracked. These kinds of cases. Especially languishing in jail that long. I don't like that either. Here's State's Exhibit 1 and 2 in this. For this hearing. Anything else? We are in recess then. Thank you.
So my question is, was this presented to the grand jury? I know there's people saying, well, we think it was. Yeah, they had the information, but was it actually presented and discussed? We don't know. Grand juries are secret. Everything that happens there is secret. And there is no defense in there. So, and there are prosecutors that will be very one-sided because they want that win. They want that. That's their job, to get it past the grand jury and to be able to convict. So, you know, I'm not buying that it was definitely shown to them. I don't know. We don't know. Who knows? Nobody knows. So, anyway, I hope he wasn't sitting in jail for 2.5 years because some girl just wants to get back at him. That would really be bad. Anyway, thank you all so much for watching, and I'll see you next time.